NPS Chawla, Secretary Pradeep Devnath, Treasurer Rajiv Bhamri sir, past Central Council member Harish Vaid sir, Regional Council member Saurabh Kalia, senior members present at today's seminar, members and members who are connected with the webcasting through their chapters. A very warm good morning to all of you. A very warm good morning to all of you. Thank you for responding back. I, on behalf of NIRC, welcome you all at today's seminar. I feel privileged, honored, and proud welcoming you all at today's seminar. The theme of today's seminar is National Company Law Tribunal Changing Contours of Corporate Litigation. The theme has aptly chosen in today's scenario. The NCLT and NCLT will change, or it's saving the litigation of the corporate in future. The newly notified NCLT and NCLT will open plethora of opportunities before company secretaries. The wait is finally over. On 1st of June, the Ministry of Corporate Affairs has notified the constitution of NCLT and NCLT. Total 11 benches has been established and 4 are in northern region, 2 in Delhi, 1 in Chandigarh and Allahabad respectively. अंत में मैं अपनों शब्दों को विराम देने के पहले कहना चाहूँगा, अगर नापना है इस नीले आसमान को तो कह दो थोड़ा ऊंचा हो जाए इस आसमान को. Now there are unlimited opportunities before the company secretaries. Moving ahead, I would like to invite Chairman NIRC-CS Manish Gupta ji, please come and present his address to the members. Sir, please.
Good morning. Shri S Chandiok ji, Senior Advocate and Keynote Speaker for today's seminar. CS Harish Vaid, past Central Council Member and Vice President ICSI. Immediate past Chairman NIRC, NPS Chawla, my Regional Council colleagues, Rajiv Bhamri, Pradeep Devnath, Nitesh, Saurabh, senior member of the profession. My dear friends, ladies and gentlemen, very good morning to all of you. At the outset, I welcome all you all on the program on NCLT being organized by NIRC of ICSI. Today's program is on very apt topic, NCLT changing contours of the corporate litigations. As you all are aware that the NCLT has been notified on 1st of June, and it is like a dream come true for all of our company secretaries. It's a battle of almost 15 years being introduced way back in the year 2002 through the Companies Amendment Act of 2002. First time NCLT was introduced, and finally in the year 2016 it has been notified by the ministry after being fought at the High Court and Supreme Court. With the introduction of the NCLT, now CLB has been abolished and all cases which are pending at CLB will now be transferred to the respective benches of NCLT. But surprisingly, till this time, rules are yet to be notified. Nobody has having any clue relating to how the applications will be filed and what will be the procedures of filing petitions and application before the NCLT in the days to come. In the first phase, 11 benches will be established. As Nitesh has already shared, 2 at northern region will be having 4 benches, 2 at New Delhi and 1 will be at Chandigarh and another will be at Allahabad. And Mr. Justice, Honorable Justice Mukhopadhyay, of retired Supreme Court Judge, will be the chairman of NCLT, and our very own Honorable Justice Mr. M.M. Kumar will continue as President of NCLT. Today, he could not able to make it to today's program as he has to attend some urgent meeting at IICA wherein all the members are getting training for the NCLT, Constitution of NCLT and the locations of NCLT in the days to come, and the matters will be dealt by the NCLTs. First phase, only the provisions relating to the erstwhile CLB will be taking up at the NCLT. That means the powers which are lying with the High Court will still to be continued with the High Court only, like mergers, amalgamations and winding up. In the days to come, all such matters will also be referred to the NCLT, but for the time being, only the matters which are with the erstwhile NCLT and some of the powers which are with the regional director are only transferred to the NCLT. Let me also share the activities of the NIRC with respect to the NCLT. Your NIRC is always on the forefront while it comes to the capacity building of our members. We have started with our 15 days master classes, and let me tell you friends, we are getting very good reviews and the feedback from the participants who are attending the 15 days master classes at NIRC. These classes are being designed to cover each and every aspect of the NCLT and NCLAT, wherein we will be having 3 moot court sessions to build the capacity of our members. As far as moot court is concerned, we are also planning to have the moot court sessions for our members in the days to come, and we have also started with the moot court at our OT classes. We have introduced the moot court at our OT classes and at our MSOP sessions, wherein our young budding company secretaries are being prepared to take the challenges of the NCLT. This particular program is being webcasted throughout our northern region. All 31 chapters are participating. I welcome all 31 chapters and members who are participating through the webcast. And the whole reason was to build their capacity. The members who are located at the different places, different regions, smaller cities wherein the opportunities are very less, but obviously they have all the rights to build their capacities. And your NIRC is webcasting this program. And link of this webcasting is being circulated to all the members, and will be also uploading the recording of this whole seminar on the YouTube. We have also constituted few core groups in the recent past, and all such core groups are based on the emerging areas of practice, particularly NCLT, real estate and GST. And we have invited the nominations from the members at large, and I'm very happy to share that almost 150 members have given their nomination to be part of various core groups. Would like to thank each one of you for participating in this NCLT program being organized by NIRC. I hope the deliberations of today's seminar will give you the insight as well as help you in building your capacities with respect to the NCLT. Thank you. Thanks a lot.
Thank you, Chairman, for addressing the members. And Chairman has rightly pointed out that the wait for 15 years is now over, and it's for company secretary dream come true. Now I would like to invite immediate past Chairman NPS Chawla. Please give brief introduction of the theme, and please introduce the key speaker also. NPS Chawla.
Thank you, Nitesh. Mr. S Chandiok, Senior Advocate and former ASG, keynote speaker for today's program, Mr. Manish Gupta, Chairman NIRC, senior members and friends. Good morning. Good morning. Thank you for responding back. Theme introduction, NCLT, changing contours of corporate litigation. Actually, it's true. It's not only changing the contours of corporate litigation, it will have many changes. Not only NCLT, otherwise also the entire litigation regime is seeing a lot of changes. You know, I remember in the last 2-3 years, may it be the check bouncing judgment Supreme Court gave, the ordinance government came out with, or the Delhi lawyers and the Delhi professionals would know, may it be the pecuniary jurisdiction of Delhi High Court, another change. Then maybe the commercial courts. Commercial courts have already been established. 4 or 5 places they have already been established. Gujarat, Himachal, Delhi. And then I remember last year when we have organized a similar program, we invited Justice Sikri, who gave this landmark judgment last year, 2015. And from our seminar itself, he mentioned the last para of his judgment, that he gave a mandate to the ministry to establish NCLT as soon as possible, because a lot of water has already flown. 15 years we have already been hearing about NCLT, nothing has actually been done. And that's how the mandate given by Honorable Supreme Court was being followed. But then came this Insolvency and Bankruptcy Code, and the provisions were overlapping. So we were wondering, in fact, 2 months back, April, I was wondering whether it will actually come, because Insolvency and Bankruptcy Code is termed as the second most reform-driven legislation after GST. GST as on date is termed as the number 1. So somehow the Insolvency and Bankruptcy Code got sanctioned. So then we were wondering when NCLT would be now established. And Chandiok sir, let me tell you, I came to you on 31st, if you recall, 31st of May, for inviting you for this program. In fact, I went to you for briefing on a matter, and there itself I thought it appropriate to request you. And before we requested you, as I shared with you that day also, we requested Honorable Justice M.M. Kumar, and Manish ji and I went on 27th of May, and this is interesting, must listen for 1 minute. I'll be finishing in 1 minute, so please be with me. 27th May, we went to Honorable Justice M.M. Kumar. We requested, sir, last year you came to 4 of our programs. We are honored, and now we are thinking that NCLT will be really becoming a reality very soon. So we will be now doing a program in June, and so kindly grace that program. He immediately acceded to our request. Last year he went to Amritsar also. Here also he came to our convention also. So he said immediately, yes, no problem, I'll jump. And I then asked him, my lord, by when you expect NCLT to actually be notified and to actually be established? This is on 27th May. And he said, now I expect very soon, and I have this circular. Now it's already made, so I'm sharing this. He showed a circular issued by ministry to all the regional director, all the ROCs, and to the company law boards also. And in that circular, it was mentioned, internal circular by the ministry, that NCLT will be established very soon, so build up the infrastructure. So I asked my lord at that point of time, Honorable Justice M.M. Kumar, so how much time you feel it will take? He said maybe 20 days, maybe less than a month, and then he shared the process. He said first the rules will have to be there, first the appointments will have to be done, the names have come out, the president has to be appointed, the chairman of the appellate tribunal will have to be appointed. So yes, everything will have to be done, and most importantly the rules will have to be notified. And before that, nobody was expecting NCLT to be constituted. And we went out on 27th. I met Chandiok sir on 31st. He also exceeded, and I was really apprehensive. I informed Manish ji that this is a vacation time. It will be very hard for finding good senior advocates, because they only have 1 month and they travel abroad. Fortunately, Chandiok sir was here. He agreed to our request. And on 31st, I remember, after I met Chandiok sir, I informed Chandiok sir that, sir, I am going out for a few days, for 15 days, for attending a course, and I will not be available for 15 days. My colleague, Mr. Manish Gupta, will speak to you and will take it forward. He said, okay, no problem. On 1st of June, in the morning, I went to Dharamshala for attending a course for 15 days where I'll have no phone, where I'll have no email access. And I had sent a detailed mail to Chairman Manish ji, writing everything, that these are the speakers, please send thanks letters, everything done for this program. I went in. On 13th, I came out and I spoke to my brother. I am done with this course, and it was a meditation course, so no speaking, no touching, no talking to anybody, no looking into eyes. So I spoke to him. I said, yes, what has happened in these 13 days? He said, lot of things. I said, what has happened? Yeah, lot of things. What lot of? Nothing changes in 13 days. He said, no, from where should I start? He asked me from where should I start? And I said, maybe you start from professional front. He said, the judgment in that matter has come up, so Satvinder ji is running here and there for execution of that judgment. He's here. So at the same time, he mentioned NCLT is also constituted. NCLT is constituted. How can it be constituted? I asked him, how can it be constituted? Rules are there. He said, no, rules are not there. On 1st of June, it got constituted. So that was another shock. How on 1st of June? I went in on 1st of June and it got constituted. So that was a small story. And in fact, I was shared that 15 days program has also been announced, which we started. Chandiok's 15 days program, we have started every day. Different topics are being covered. Different aspects of NCLT are being covered. So as far as today's theme was concerned, we discussed this theme, and in fact this theme was the theme chosen by Satvinder ji for one of his session in Lucknow, and we borrowed that theme for our today's seminar because we liked the theme so much. And so again, we day before yesterday we went to Honorable Justice M.M. Kumar because I got a call from his office that he will not be able to attend this program since everything has now been done. In fact, vacation bench was also there for NCLT. Matters were being heard. Till 9 o'clock, vacation bench, NCLT has heard the matter. In fact, our matter was being heard on last Thursday till 9 o'clock in the night, not in the evening even. And so we again went to Honorable Justice M.M. Kumar. He said, please spare me this time. I'll be surely joining at some other program. This is a very critical stage. The new members who actually don't have much of corporate law background have to be oriented. So from today onwards, in fact from tomorrow onwards, their orientation program is being organized by IICA of all the members. And in fact I have heard the appointments for, and in fact I don't know how many of you know, NCLT has also been constituted. In the sense NCLT has also got the opportunity to handle the first matter. This was on 17th of June, which means last Friday, not even last Friday, this week only, 3 days back, a Bombay matter came up. An appeal against the interim order passed by a member was heard by the chairperson for NCLT without rules. So I went to the bench officer asking where are the rules, how have you listed the appeal, because I was expecting an appeal against one of the orders which we got in our favor. So he said the simple process we are following till the time rules are being notified is that we place the petition or the appeal before the chairperson or respectively before the president NCLT, which means Justice M.M. Kumar, and then they decide if the matter is urgent, then they'll list it for hearing. So with this background, we thought if he is not available, let's introduce one more session. Otherwise, the topics which we thought for today, today's seminar, and which are very, very important, honestly. Today's seminar, I'm sure, and particularly the members joining through webcasting, 31 chapters, huge numbers. The reason why I'm saying so it is very important is, one, as far as technical knowledge of company secretaries is concerned, time and again at different forums, and I am sure Chandiok sir will also agree and he may share his view on that aspect as well, that as far as technical knowledge of our members are concerned, there is no doubt, nobody can challenge that, vis-a-vis other professionals, particularly for company law, corporate laws. As far as the appearance skills are concerned, because in our curriculum, this subject was earlier not there. Now we have introduced it at every level. Manish has already mentioned about it. So our first session today would be on art of advocacy and courtcraft. Senior advocate Mr. H.L. Tukku would be joining very soon, and Mr. Tikku would be talking on that. Second most important topic, insolvency and bankruptcy code. Satvinder ji would be talking on that. There's so much of work which will flow from insolvency and bankruptcy code for us, for professionals, huge, and a lot of changes, and a lot of repercussions are there which I don't, in fact I haven't read because I couldn't read. On 28th of May only it got, President accepted and it got notified, thereafter 15 days off and then all. So today we'll also be hearing from Satvinder ji on the insolvency and bankruptcy code. We'll also have an opportunity to hear Mr. Krishnendu Datta, who is an advocate, on very important aspect, judicial principles governing oppression and mismanagement. And then the last but the most important would be the opportunities which our members have. Nisar ji would be talking, our own past president, Mr. Nisar Ahmed, would be talking on the procedural aspects and the opportunities for company secretaries. So this is the overall background and the overall theme of the today's program. Now moving forward, now I request our keynote speaker, Mr. Amarjit Singh Chandiok, to please come on dais. Request you all to give a big round of applause. Thank you, sir, for acceding to our request. We initially thought that we'll have a detailed inaugural session, but that's at the same time I feel when I spoke to sir 3-4 days back, sir sent me a message that what is the coverage and what I need to speak on. So I said, sir, I don't need to tell you what you will speak. I mean, I can surely share what we are covering, and I'll share about it a little later. So moving forward, request our former Vice President, Mr. Harish Vaid, to please come over and present a flower bouquet to, in fact, it's not a flower bouquet, it's a green plant, as evergreen as our Chandiok Saab. So we thought to have this green plant instead of the normal flower bouquet which has a limited shelf life. So with this green plant which will live forever like our Chandiok Saab, big round of applause for Mr. Amarjit Singh Chandiok, who although needs no introduction, but I am duty bound to introduce him. I remember last year we organized one program on competition law. I don't know how many of you attended. And at that time also I requested Chandiok sir to be the keynote speaker. Mr. Ashok Chawla, the then chairperson of Competition Commission, came. And that time I remember what I shared. That was a program on competition law. So I said, although we are doing a program on competition law, but at the same time the keynote speaker, which was coincidentally Mr. Chandiok only, there is no competition to him. I mean, he has been a legend. Mr. Chandiok has always been a topper. Mr. Chandiok was a topper in his law, also won the gold medal. He's been honored with 2 honorary doctorate degrees, one by Word Sikh University UK and another by Amity University. Still he doesn't use Dr. Amarjit Singh Chandiok because he feels his name is enough, and the work which he does is beyond par excellence. He was designated as a senior advocate in 1999. Thereafter, he was also appointed as the Additional Solicitor General in year 2009. Mr. Chandiok has successfully represented many corporate bodies, government agencies and departments. He has also been the president of Delhi High Court Bar Associations, and that too, I don't know when his record would be. I mean, anybody can even imagine and dream to break his records. The position of president of Delhi High Court Bar Association he occupied 6 times. I mean, which deserves a big round of applause. Trust me, I mean, contesting for President Delhi High Court Bar Association is one of the most difficult elections which anybody can plan to contest. And whenever he used to file his nomination, immediately upon filing, everybody will say he is already a winner. There is no need to, for him to do the election campaigning. And that's only because of his stature. That's only because of the work which he has done. That's because of his helping nature. That's because of his positive attitude. That's because of his forever helping hand to anybody and everybody. That's the quality of Mr. Amarjit Singh Chandiok. He was also honored as the outstanding jurist in year 2000. He's been honored as the leader in the profession, Leader of Bar Award 2007. He's also been honored, and this very proudly I share, as Sikh of the Year 2010 by Sikh Forum International, London, UK. And apart from that, he's such a great academician. Trust me, whenever we go to his chamber to brief him, even if we are busy, the entire team will go. We have 4 people in our team. All 4 of us will go. And we generally say, sir, you may not know I'm sharing, that chalo today we'll have another opportunity to have Chandiok sir's Pathshala. Because when we go, the kind of strategy which he develops, unparalleled. Litigation is all about strategy. It's not only about law. It's not only about judicial judgments, the judicial precedents. It's all about what you plan, what you strategize before you enter the courtroom. And that's what sir does brilliantly. I mean, I've been briefing many counsels, but he has no match. the kind of strategy which he develops and evolves unparalleled. So would again request you to give a big round of applause before I request Chandiok sir to please come and share his words of wisdom with us. Chandiok sir, please.
Thank you so much, my dear Mr. Chawla. I don't think I deserved any of those kind words from you. Thank you all, first of all. Thank you, Mr. Harish Gupta. Thank you, Mr. Vaid. Thank you, Satinder. Each one of you here. And I must tell you all that today's greatest joy to me is to see you all in time for a seminar to be learning part. I think that commitment itself to me gives me a sense of joy that I feel today still, notwithstanding that all our professions are going down the drain, excuse my saying so. We are missing our values, we are missing our commitments, we are missing our brotherhood. Yet when I find all of you here, itself gives me the strength that I can live for a few more years to be part of this bar. Thank you so much for being that one. Lot was said, though I came to say something else. Let me start with something else totally different. And that's what I told Mr. Chawla, what do you want me to speak on? I was in fact going to tell my Lord Justice Kumar that God never gave me the privilege to sit on bench with you, but at least I must thank my dear friends here that I'm sharing a podium with you. But look at the God's will, even that was bit deprived today. But it doesn't matter, we'll look at some other occasion to it. In fact, what I wanted to share with His Lordship was, and I want to share with all of you, and I want to put that question to myself and request you to answer it. If my Lord Justice M.M. Kumar, after superannuation, demitting his office as Chief Justice of Jammu and Kashmir, is good enough to be President of NCLT, then where was the need for him to first superannuate? Today, the whole purpose is today that he was contributing not only to Companies Act, one had the privilege to appear before His Lordship on many occasions, both here and in Jammu and Kashmir. The whole rut that is going on today in the judicial system needs to be curbed, to my mind. And one of the steps that the government must take is that they must increase the age of the High Court judges to 65. So that there's no competition to cover that kilometers from here and there to reach to the Supreme Court. And look at another aspect. We have created new tribunals one after the other. Mr. Harish said, Mr. Chawla said it's a dream come true. I do not know whether the dream has come true or not. The reason is manifold, and one reason they all have given themselves. We have asked the Act to go into operation without an infrastructure. We have brought the Act into force without the rules. And look at the irony. The people who are going to preside are learning their lesson today. And they are going to preside over those benches. And I had put this question to many professionals of my colleagues in the bar as well as to you all. Why can't the statute provides? Mr. Chawla rightly said that what is your technical knowledge, what you know of company law. I am an infant there, I must concede that part. Forget the fact that I'm a keynote speaker. That keynote speaker doesn't make any difference. I'm an infant before you. However, why is the government one after the other not looking at that I will appoint members to a tribunal, I'm assuming tribunal has to go through from company secretaries, chartered accountants, lawyers. If you are looking at a specialized subject, then why are we not doing that? But we still look at an additional secretary looking somewhere in minority ministry or somewhere probably in agriculture ministry, he'll come and preside over Companies Act. This is where the fathom of whole thing is coming. And therefore, with all respect to all of you, my personal view is tribunalization needs to be re-looked at by us. It is heartening to see, no doubt, that a new Companies Act come in. It is heartening to see some new features coming in. But the question is not that. Question is, how will you implement? As Mr. Chawla just said, you have no rule and you are hearing an appeal. How is the procedure being given a go-by when you are actually doing justice? And if you see 2015, I think Justice Vikramjit Sen has said, we have evolved by empirical evidence procedure of this country which we must adopt. And where was the hurry? You could have created an infrastructure. I wish Justice Kumar was here, he would have told you. His first day as president, I was the second person appearing before him. And there was no lift. One had to climb 6 floors up to his courtroom. There's no bar room. There's no infrastructure there. Therefore, when you are asking people to be part of justice delivery system, please ensure that your infrastructures are in place. Your rules are in place. And therefore, I said, you need to look at, you have actually entered a storm. Mr. Gupta, I do not know whether we all will be able to weather it out or not. But having said that, I must accept also that lot will depend on us. Doesn't depend on the bench. And it reminds me of Lord Denning when his lordship was sitting in a court of appeal. And his own judgment was cited before him. And he told, and I think the name of the Queen's Counsel of Mr. Williams, he said, my dear Mr. Williams, you were not the counsel assisting me then. It is the assistance from the bar, it is the assistance of people who are appearing before me that shows me a new light every day. For me, a sun shines when I'm sitting as a judge from who is assisting me in the matter. Therefore, a larger duty to my mind, though the dream has come true, would be how much we put in our effort collectively together to ensure that this new dream which we have got is actually implemented. For whom? For that consumer of justice. Therefore, please take that responsibility. And heartening to see, I wish bar associations would come and follow your principles. If all bar associations in the country, and all professionals for that matter, would learn from you, for which I must congratulate you, that this process of learning that you have brought in to your curriculums, to your seminars, to your courses, is actually the need of the hour. Because we do not know, the law is not static. Every day there's changes. Look at May itself. And in fact, this morning, a question was put to me by somebody, because yesterday's change by United Kingdom, Mr. Kejriwal also said, I want to do a referendum. No, we are doing knee-jerk reactions. He says, I'll bring a legislation on people's will. And I think that word, we the people, in the Constitution, we all have started misinterpreting it. Not realizing that the legislative competence of Delhi is not there to amend the Constitution. And should there be a vote to see, or should experts in the field not sit down, put their heads together to see how does the government has to function? What are the rules of governance? Or should I go back to people and ask him? I do not know, I don't mean in political part, please forgive me for this. To me, whether I wear a cloak of Congress, BJP, NDA, AAP or no AAP, we all are one class. I don't think any one of us has been able to deliver what we need to deliver to the people. Therefore, the need for today, and people like you are intellectuals, people are you who are actually knowing Companies Act, would have to stand up tall. Stand up so tall that people on the bench start thinking, who is appearing before me today? And that is where your law will actually evolve from here and after. Provisions are there, but the question would be interpretation. Who will interpret them? They. And unless they can't interpret without your assistance. And look at the interplay today. Part of the system has come to NCLT. Part has gone to DRT. And DRT is disaster. Those of you who have ever been to DRT, you would know. I have a report with me of a very eminent lawyer who used to practice in DRT. And he says, out of the 4 recovery officers that he examined and surveyed, all 4 were not above board. If this is the system that we are looking at, and we must see a judgment by Justice Pradeep Nandajog, I think 2016 itself, where the Lordship says, what is the DRT doing? Its purpose is totally different. But we go into different category altogether. We failed in our civil system, we brought DRT. We failed in DRT, we brought SARFACI. We failed in SARFACI. Before that we brought SICA. Now everything is clubbed into Companies Act. 470 sections. I don't know, I'm sure most of you would have read it, more than me. 300 of them provide as prescribed by the government. Please look at it. So the role of the government is predominant. You and me can't do anything. Court can't do anything because he has to prescribe. And please consider it from the light of this part, that government in after 1991 scenario, when we changed the system of this country in economic reforms, and we've passed 25 years now, nobody remembers that man who brought that change, Dr. Manmohan Singh. But we must salute him for what he did to this country. That's why we are today 2 trillion economy today. You and me would not be sitting here today, probably. Probably Britishers would have started to come back to us. Gold had already gone. But be that it may, the question that I'm posing to you is this. What will be the scenario then? How will you interplay these acts when person who is a litigant before your company law board is a creditor? Look at the private-public partnership. Let me give you one example. Under the mobile industry, most of you will know, the licenses are to Tatas, to Birlas, to Ambanis, to everybody. And there's a revenue sharing. And supposing a Tata's company or a Birla's company or a Ambani's company in liquidation, then what will you do? The government will stand as a creditor before the company law board. And that very creditor is actually the person who is prescribing in 300 sections of your company law. And look at a new scenario. A new authority has been created, NPRA, who will look into chartered accountants' misconduct, notwithstanding that the Chartered Accountants Act. Therefore, over and above that, a new authority comes in to look at my conduct. And let me share with you all, with a sense of shame, I must say that to you, that my disciplinary authority today, the Bar Council of India, unfortunately has 13 people being prosecuted for A, B or reason. I don't want to go into those questions. The question that I'm raising is, do I need another authority over me to prevail over me in my disciplinary proceedings? Notwithstanding there's a statute, there's an authority. Look at yourself. If supposing there was another authority constituted over you, then what is the need for this, all this seminar to come for? And my friend Mr. Chawla mentioned about the new Insolvency Act. I only wanted to share with you all that for 17 years we have worked on this insolvency regime as part of Insol International, Insol India. There is a society of insolvency practitioners already in place under the Ministry of Corporate Affairs. And you have created a board now under the code. And they want Mr. Chandiok will now go and register himself with the board. These are the aspects that need to be thrashed out by us. My friend did say, Justice Sikri said he was a far-reaching judgment. There's no doubt about it. But I do not know myself whether it was right. Because if you read the judgment of the National Tax Tribunal today, I find no reason why should there be a company law. The argument is the same. And I think, if I'm not wrong, if my memory is not failing me, Justice Nariman says there, the legislature has crossed its Lakshman Rekha. It has crossed its boundaries to intrude into a system which they could not do. And please consider three aspects. Before I take you to some aspects of company law, I don't think it will be an infant talking to experts on it, but now that I've been cast with duty, I'll do that. Under the Constitution, the Supreme Court is created. Under the Constitution, a High Court is created. Under the Constitution, subordinate court is created. And there are only two articles in the Constitution, 323A and 323B, which empowers the legislature to create tribunals. One is the administrative, what we have, CAT, Central Administrative Tribunal. The other was for taxation. Now, where are you getting this jurisdiction then? When the Supreme Court gets stuck on this part, the Supreme Court takes a way out. He says, no. List 1, entry 77, legislative power is there. I'm not against tribunalization, but I'm only requesting you to look at what was being dispensed by a constitutional court. You want an additional secretary to dispense with. Would it be proper? It's a sovereign function of the state. Therefore, that 42nd constitutional amendment itself was bad, to my mind. And look at the judgment now that we delivered in the Supreme Court, where we said you can't take my right as a collegium member to appoint judges. The constitutional amendment was struck down. Why? Because the basic structure of constitution that you're looking at. Then where did the basic structure go when it came to Supreme Court, High Court and a subordinate court? We were going to go by to that. Therefore, the question that I'm posing for all of you who are intellectuals and intelligentsia of this country, I'm conscious of the fact that I'm on web. I'll be quoted. Maybe tomorrow there's a contempt petition against me, doesn't matter. I've faced many. One more will come. Because the first thing that my guru taught me when I became a lawyer, and I must share that with you all. When I went to his chamber, he gave me a file. He gave me a book, CPC, and he gave me, I think, High Court Rules and Orders. Placed them in my hand and said, from today you're not a Sikh. I was taken aback. I didn't know that I have to change my religion. But he said, no, my dear son, this is actually your religion. This file, this book. If you do justice to this and enable this to dispense justice to people, then actually you are praying to Almighty, irrespective what caste, color and creed do you belong to. We have ruining our systems by bringing these half-baked situations. My friend rightly said, there are so many sections overlapping. Who will exercise jurisdiction? Look at NCLT. If I'm a guarantor and part of a company, NCLT will deal with me. But if I'm an individual, my insolvency will be dealt by DRT. Now question would arise, If my insolvency petition is pending before NCLT, another petitioner files a petition before the DRT, who will have supremacy? Nobody knows. Therefore, most of the time you will keep looking at yourself, where should I go? Is that the law that we need in this country? And Mr. Manish was right, absolutely. 15 years we have taken to bring a legislation. And after 213 Act, 39 circulars have come. Clarificatory. What kind of act it is? And since you know better than me, in 1956 Act when it came, within 1 year, we brought Justice Mr. Vishwanath Shastri was a judge of the Madras High Court and an extremely capable lawyer in the country to relook at the Companies Act. Because we thought, no, it doesn't work. Now you do not know the interplay between the sections. Look at the legislation that we are covering now. We are covering SICA. And SICA was a complete failure. We saw that. BAFR and AFR were disaster. It did not bring any rehabilitation in the industrial world. Let me take it from me. Those of you who want details, I'll give you. Many of you are industries conscious, you must be knowing about it. We have seen in BAFR, to my own knowledge and to my own presence, BAFR member walking out to say, I would not like to hear this matter because I don't like this person who's appearing for the bank. I mean, this is the state. You are connected with taxation. Let me share that with you since it just came to my mind. We had a sales tax appellate tribunal in Delhi, what is now called VAT. And I'll give you another example, living example, which is happening today. A member will stand up, I think, if I'm not wrong, it was Mrs. Bali or somebody. Because she gets a phone call, she walks out. Matter is going on. Hearing of an appeal is going on. She'll come back. Second man will go back. It reminded me of I thought Justice Kumar was here to share that with you all. My Lord Justice Singhvi was a judge in the Punjab High Court, sitting on a division bench. And his Lordship was concentrating on his file when the next judge just walked off. He didn't realize it. The counsel realized it. And obviously, one had to stop. So Justice Singhvi asked me, why are you stopped? I said, my Lord, I need to look at something else. I didn't tell him that your partner is not there, boss. Till the judge comes back. So he says, my bladder was so full I could not wait. No. What are we talking about? I am only bringing these incidents. These are anecdotes. There's no doubt about it. They're hilarious. But what I'm bringing to your notice is this. I need judicial discipline. When I came to the bar, a junior judge would not speak. He would tell his senior to speak. That was the decency. And that's why it gives me pain when I tell you, how many people today, when you will sit in the company law, tomorrow NCLT proceeding, you will find my younger friends will keep sitting, my senior most friend will keep standing. We need to bring those values back to our bars. We need to bring us back to that forum. We are not supposed to be commercial, what we are beginning today. This is just the need of the hour today. We saw income tax tribunal. In fact, my friend told me on 31st and 2nd or 3rd, I think, income tax appellate tribunal chairman spoke to me and the president to say, sir, we have no vacancies. We have so many vacancies, there's nobody there. In CLB, a 9-member tribunal, we could not appoint. No government could appoint 9. And we have now 62. 62, I think. Yes. How will be? And therefore, why are we not looking at you? Why are we not requesting Mr. Manish Gupta or any one of you here, you please sacrifice for the cause of justice to deliver this, even if it is for a shorter period. But nobody wants to look at that. I therefore say it's a dream come true, no doubt about it. But I have my doubts. How will it push through without you being strong enough to come forward? Because please consider, for 80 years before we brought CLB, the jurisdiction was with the High Court. And with LLP coming back to your fore, that Lawyers Advocates Act no longer comes in your way, really speaking. That's my personal view. My bar may not agree with me on this issue. And if I can appear in person, please consider, then why can't I not appear with an attorney who may be a company secretary, who may be somebody else? You can have my power of attorney and appear. So this clash that we have started bringing within our contours, that he is a company secretary, he can't come to the High Court. Why? If he is competent, tell him. My friend said I have no competition. I don't agree with him. We have designated 175 seniors till date from Delhi. 45 or 50 of them probably have either gone aboard or been elevated to the judges. And you won't find more than 20 in the court. Not more than 20. To that extent, I agree with Mr. Chawla, there is no competition. But we have still designated them. Therefore, the merit is the requirement of law. Unless I bring merit back into it, this caste color creed must stop. In fact, I chose Justice Thakur the other day, before this paper came, where he was visiting to the United States, that Master Tara Singh was an Akali leader, and he went to Panditji one day and said, well, 12, 15, 14 years have passed. There's no sixth judge in the Supreme Court. Panditji said, nothing came before me. If somebody would have come, I would have definitely looked at it. Panditji met, and this is part of a record, I can show that. Panditji met the Chief Justice of India then and pointed out this fact that, could you please consider if a Sikh could be appointed as a judge to the Supreme Court? And you know the reply of the Chief Justice of India? He said, the Honorable Prime Minister, Supreme Court of India is the apex court of constitution of the country. It's not a zoo where I need all species. Which Chief Justice will have the courage to say that? And which Prime Minister today will have the courage to accept that? That is the leadership that I need today, both from the bar and the bench. Then only this act, my dear friends, would actually start functioning for the purpose for which it has been brought about. Look at the small thing in your amendment. So far, he has already clarified, my dear friend, that mergers will still remain in the High Court. So please consider, most of you have done those mergers. I have to take permission even from Competition Commission of India. So should I go to Competition Commission of India or should I come to NCLT or whenever it gets the jurisdiction? The High Court was issuing notice to two people, Registrar of Companies and Regional Director of Ministry of Corporate Affairs. The Act now says, give it to everybody. Income tax, sale tax, this tax, that one, including exchanges. So that merger situation, on one hand, my slogan is, I'm very business friendly. And the other hand, my enactment is this. So a lot of time will be wasted in everybody saying, I'll file my objections. Therefore, that merger, which is actually the need of the hour for that business entity, would go down the drain. Sometimes Ministry of Corporate Affairs will say, I have no objection. Ministry of Communication will say, no, I have objection. You all know Section 72A, if I am not wrong. Set off of losses. Income Tax Act's taken those questions right up to the apex court and not allowed mergers to take place. So what are we looking at? There is no, with respect, a legislative competence by which any legislation is drafted in this country. Let me share that with you today. Your own provision. When I file my annual return, I have to file it as of 31st March. Supposing EOG has taken place, new additional directors have been appointed, nothing will come. Return will go in September, but as on that day, as if it's a financial year to go through. A person, the purpose of that was that a person who wants to deal with you should come to know who is there in the company. So anything that changes from 1st April to September, he doesn't even know. So we close our eyes when we want to enact something. But having said that, I must say, there are heartening features. There's no doubt about it. It would be wrong on my part to say that the act is full of powers, only follies. No. But the first question still arises. A distinction between NCLT, a consumer forum, CCI, so many. Is this a tribunal? Then what is that? There is a tribunal presided over by a retired Chief Justice who is going to look at your merger once the jurisdiction comes, or sitting judge of the Supreme High Court. But on the other hand, we find CCI sitting. Mr. Tikku, welcome. And I must share with this audience, Mr. Tikku is my papa, both in law and otherwise. A great eminent counsel at the bar, with whom I have learnt my lessons. So in fact, speaking before him itself would be dangerous, but anyways, I'll venture to do that. Though going back to that situation, some is called a forum, some is called a commission, some is called a tribunal. What is the difference? Some authorities are still with the government. You file an appeal to a secretary. He is also adjudicating. Therefore, the legislature needs to iron out everything and put it in the right perspective. And please take it from me, my experience at the bar tells me, there is no tribunal in this country which has actually been presided over by an expert. None. Let me give you an example of TDSAT. I have seen Agriculture Secretary sitting there. Minority Secretary sitting there. What he will know about neither law nor of the telecommunication. And when I know that somebody is going to retire, TDSAT is without the head today. In all tribunals in the country, my last figures were 43% are lying vacant. DRTs, Delhi, where the jurisdiction has gone, 3 presiding officers are not there. One is fighting a battle in the court, the other one is probably presiding. I don't know. Then why are we creating these forums? At a function speaking for DRT, and I had said, what prevented us to give that jurisdiction to an additional district judge and to a sub-judge to execute that decree? What prevented? My friends mentioned commercial court. On a lighter vein, I must tell you, commercial courts got constituted in Delhi. Fortunately, we have a high court on the original side. And my friends, you will be astonished to know, my bench is commercial court. And what am I hearing? Matrimonial cases. A commercial court is hearing matrimonial cases. Therefore, that I agree that statute is there. There's no doubt on that. But implementation of that statute becomes important. And nobody looked at it. In Delhi, there's already a commercial court provision. I had a commercial court in district court even. And today, looking at the litigation that Delhi has today, my dear friends, we have surpassed any other high court today in the country. You won't get so much of commercial litigation even in Bombay. Calcutta is far, far behind. Madras has ruined itself. When a judge starts walking from his chamber to another judge's room to say, I want to file an affidavit, then you know what the court would be. Now, therefore, what are we looking at? We are looking at who is going to dispense and administer this act. And I have two follies there I already pointed out, not going into that question, that it has 1956 Act, was amended 31 times. 31 times. And sometimes twice in a year or thrice in a year. So why are we creating that statute? Why can't we put those experts who actually do Companies Act to sit down, put their heads, and then draft a legislation? We will not like to do that. From 700 sections, as I said, 417 have come. But if you look at it carefully, you will find subsections have been added to the same sections. So Mr. Chawla will stand up and oppose me in a petition to say, look, section 410, subclause 1, defeats 416, subclause 3, because they're totally contrary to each other. So numerical is not the problem today. And unfortunately, this country, every politician, every judge, everybody says backlog, 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 backlog. But why is the backlog, brothers? The backlog is because we have not brought ourselves up to date to assist them, one. And secondly, with all humility at my command, I am not producing judges who actually want to listen and do justice. The moment I sit at the chair, I start feeling, my God, every wisdom has fallen on me. At my, I don't know, before me, it must have been, my dear Papa can tell you, maybe his experience is much more than me and mine. But when I came to the bar, and when I was the president of the law, I had gone to meet a legend, Mr. H. L. Anand. At that time, in 1971, the gentleman had an office at Sansad Marg with 80 lawyers with him. He had a heart attack and was elevated to his bench. When I'm appearing before him, he tells me, Mr. Chandiok, this Designs Act I have never done. I have not read it. Will you please read the statute before me, one by one, so that I understand what is the theme of that? He was not ashamed to tell me, I want to learn. Unfortunately, the judges today feel they learn most. And my senior would bear me out. We had an honorable judge who was Justice Serene, a very dear friend otherwise. I had no knowledge that he had selected the chairs of the High Court. So there was some incident that had taken place and he was taking my class on that, being the president of the bar. So I said, Lord, could your Lordship lend me your chair on Friday? I want to get it chemically or otherwise examined to see. There is something wrong with this chair. Little realizing that the chair was selected by me. He says, no, I've done a lot of work to get this chair selected. I said, I was not on the selection of the part. Therefore, I need people who adorn those high offices, who not only have knowledge, but also want to learn. Because law is every day. Every case that comes before me gives me a new angle, a new point to law. We have a special resolution to alter articles, change in the voting percentage. We'll have the approval of the NCLT. So how will you do this now? Then terms and conditions of conversion of debentures issued to the government into shares has to be obtained from the government by the company. My friend just now told me, the rule comes in that I will take a deposit only for 1 year. If I have funds and I have faith in the company that I can lend it to it for 3 years, it's a contract between me and the company. How does the statute restrict my contract? But we've done so. It's good to see debenture trustee coming to NCLT for an order to impose further restriction on incurring any further liabilities in the country after the debenture. And those of you who have seen foreign investment being invented into this country, you have seen people who had particular amount that if you pay me this much back, then I'll be able to take. It's an option available to him. The Reserve Bank came in and said, no, you can't do that. You'll have to have the market value of the share on that day. Now, if I'm a debenture holder, I'll never allow the company to progress. I'll say, put more restrictions on Mr. Vaid. He can't have more money from anywhere else. So are you not impeding into the progress of system? And I was just sharing with my friends, I think the greatest harm to the institutions of industry has happened is by the Supreme Court. Excuse my saying so. If you had no 2G, if you had no court judgment, you would not have your people running up and down for the purposes of putting their, many of their own, government's own stations are not working because there's no coal. Now they want to bring some new factors so far as auctioning of the queries are concerned. So on one hand we say we are opening up everything. On the other hand we are imposing everything on us. I was telling them, and I had the privilege to sit with Justice Ganguly on the podium, and a question was asked from me, since I was the person representing the government in 2G, one of me, that why did you not tell the court that these people, all of these people, maybe that their licenses were wrong, yet they have created an infrastructure, they have given jobs to people, there are so many families being fed. Could you not look at an alternative? I thought Justice Ganguly would answer, but his lordship did not, so I had to stand up. I said, yes, I did argue. I gave an example of Unitech. Unitech was one of them. To say if Unitech has land holdings in various parts of the country, ask him to file an affidavit. Where does it have? Issue notice to those states and state, what do you need? Do you need a hospital, an institution? And ask the experts of that field to come and manage it for them. That should be the punishment they should give them. But lordship thought I was talking crap. Though fortunately for me, Justice Ganguly stood up and said, yes, we ought to have looked at it. Now these are matters which we must look at. Though this is a ground for us to look into this situation. But the enactments that have been covered into NCLT, they are so overlapping. We had only 4,000 cases, I'm sure those who you know better than me. When Justice Reddy gave the first report, there were only 4,000 cases in the country on Companies Act. Yet we created it. And those of you who traveled outside Delhi, you will find there are high courts where a company judge does not even sit once in 2 months. Bar is not Mr. Harish Salve or Dr. Singhvi or my friend Mr. Tikku. Bar is that lawyer, and it was I think it's very heartening for me to note that you, my friend Mr. Harish Gupta, said that I am connecting those people who otherwise at smaller cities are not able to understand this position. Must congratulate you for it. I must reach out to those people. The high courts have no functioning. The Arbitration Act. The Section 11 petition, Chief Justice sits or the judge designate sits once in a month. So what will the Chief Justice remember on what is Section 11? Therefore, please ensure, have that courage, I'm sure you all have, to bring the right to the court's notice, irrespective of what the consequences are. We saw yesterday in a vacation court, my friend said the CLB was working till 9 o'clock. The High Court was also working till 9 o'clock. A dispute is between the private secretaries of the judges and court masters. So we in our wisdom decide we should bring more private secretaries. 36 judges, we already have 49 private secretaries. We want to induct more. So that's what I was challenging. So I said, when will the court itself decide that Article 14 also applies to the court? It not only applies to the executive functions. The matter got adjourned for next week for the reply to the High Court. But that's the problem today. And please, my friend said 17 June, first appeal was heard by the appellate tribunal. Where was the need to create one? Assuming the NCLT has ultimately, we all push it through, we all put in our efforts and push it through. The appeal from CLB used to go to the High Court. Now you brought an appellate tribunal. And you are making that apex court as an appeal court, where constitutional questions should have come. And that is my reason when I said to Mr. Chawla, then if when you are examining the National Tax Tribunal, you said it is bad in law, there was the opportunity to my mind for the Supreme Court to re-examine L. Chandra Kumar and R. Gandhi's case once again to say all these are bad in law. To my mind, it failed in its duty to do so. Because if you see the theme of these two judgments, it's the same. And I think I have a quotation from in the Madras High Court Bar, para 119. And it says, the Supreme Court cannot appreciate, we can't appreciate. And it's an erroneous assumption that company law matters require certain specialized skills which are lacking in the honorable judges of the High Court. This is part of the judgment. Yet it went on to uphold the constitutional validity and stating that the technical members should be secretaries and additional secretaries. I didn't know what does it mean, how do you reconcile the two situations. Let us look at it. I have no doubt the judiciary of this country has brought laurels to us. It has done a tremendous job. But we must also accept that on many occasions it has also done erroneous judgments. Because I am not able to reconcile the jurisdiction of the Supreme Court under Article 32 and 226 of the High Court when it came to their own collegium system. And when you erode the system, irrespective of 323A or 323B not applying. And this part is not today's doing. I can take you back to Keshav Singh's case, Manavra Mill's case, so many of them, Keshav Bharti's case in this regard. There's nothing new that they've done. But when it comes to A, you take a different viewpoint. When it comes to B, you take a different viewpoint. And that is where the law is not becoming static. And my worry to my dear friends is this: how will you advise your client if you do not know what the law is? If you see, you take up a volume of the Supreme Court in 1998 or 1997, if I'm not wrong, you'll find 9 judgments of the same judge on specific performance. And all 9 judgments are different. So how will you advise somebody on specific performance if the Supreme Court itself is doing dig-dang? "34 is interpreted one day by one bench of the Arbitration Act to say parties public policy. Second day another judge files another thing. And now the latest says, if it strikes my judicial conscience, I'll strike it down. Therefore, the point that I was making, judicial discipline only doesn't come that I don't walk out. Judicial discipline also comes, I must see the ground reality of my effect of my judgment on common man. on lawyers, on litigants, on people, professionals like you. So if one bench of company law board or NCLT will pronounce one judgment and the second bench pronounces another one, then my friends, I doubt how will you be able to advise your clients. And in fact, Justice Nariman in the tax judgment says, and quotes Lord Acton, and let me quote that for you, their lordships entertain no doubt that time alone will not validate an act, which when challenged is found to be ultra-virus, nor will a history of a gradual series of advances till the boundaries finally crossed avail to protect the ultimate encroachment. These are his words from the tax judgment I am quoting to you. And yet, we upheld the constitutional validity of this act. I am sure deliberations in the next few sessions will give you more insights of this act. But on 5th May 2016, another act came in, which Mr. Chawla mentioned. I think 28th May it got the assent of the President. The National Insolvency Code. How will these two acts now function with each other when the provisions are overlapping? Nobody knows. And you'll find sections in both the provisions. It says it's in addition to an existing law. So in addition means that I'll either have to wait for NCLT or I have to wait for DRT. Therefore, this situation is, our laws do not facilitate speedy and effective enforcement of management because there is no single comprehensive law which addresses all aspects of insolvency. Though I think it's a right step. It's a giant step by the government, no doubt about it. Because we had 1820 Act or 1829 Act of Provincial Insolvency Act, which were now repealed by it. Now, UNCITRAL is in place last 20 years on insolvency, and we have given it a complete go-by. Cross-border is the problem today. You saw this morning's paper. Indians who have invested in United States or United Kingdom are worried. What will they do after the referendum? So it's the cross-border insolvency that is troubling us. But we have given it a complete go-by in this code and asked DRT to preside over an insolvency proceedings. Could you please look at it? If I'm a judge sitting in DRT, I have to recover the dues for the bank. Whereas I have an insolvency petition before me, where I have to protect the insolvent also. So are they not self-contradictory? The two run totally parallel. They're alien to each other. Still I have conferred jurisdiction on them. And let me share it with you. The reason was only one, because I'm under pressure, therefore I'm saying to you that we must bring those rules under the insolvency regime by 30th of June. Because there's a World Bank report which has to take place of our credibility so that it may go up that we have brought insolvency regime. That can't be the reason for bringing law, my dear friends. Many people cite UK as 1 year for insolvency. United States is probably 1.5 years, but we take 4 years, 5 years for insolvency proceedings. But has somebody realized that OL doesn't even know the spellings of company? If you ask him to spell company, he will not be able to do it. And he's the OL. Then how do you expect him to do so? But yes, fortunately, we have brought this system now where professionals like you, as my friend said earlier, are brought into the picture to look at insolvency professionals. A great opportunity for all of us, I know, but I do not know whether it will be worthwhile to look at that opportunity. I only feel time will only tell what will happen in that. Though the Commission has said that we have built up, many building blocks have, for the first time in insolvency, but I think many building blocks have also been broken there. So we don't know where to go about it. Though I still feel we have to look at them in positive way. We must stand to see how. Now under the Act is 180 days for insolvency. How do you expect 180 days to finish this whole proceeding? To me is doubtful. Until 75% of the creditors don't agree, I can't extend it. So what will happen? I'll again file a petition to the High Court, exercise your jurisdiction to 226 to extend it. Then High Court say, yes, I have no bar. My power under 226 is not taken away, or 227. So High Court will say extend it. So I'm not looking at it, and I must share with this August gathering, when I first learned my chapter as a mediator, the first thing that was taught to me was, must see what is the underlying dispute. What is the root cause of that problem? And no legislation is looking at what is the actual cause of that problem to see that. But we bring legislations after legislations without even looking at what we should be doing. Let me only end by saying, time does not permit me to put to an infant to bring before its own fathers in Law of Companies Act the various provisions of this act. As I said, I am actually an infant before all of you. You would know the niceties of company law much more than I even learnt ever. But whatever I thought, I must bring to your notice, that's a very great responsibility on your shoulders. Your shoulders, I'm sure, are very broad. God has vested you with it. And with the energy that your associations are showing, I'm sure time is not far when you will iron out the various clauses of the Companies Act, and we shall be able to do something better. I accept that today tribunals are an essential part of our justice delivery system, but I still feel it needs to be relooked at. If you look at those of you who have ever been to looked at district courts, you will find we have rent control tribunal, we have motor accident tribunal, we have MCD tribunals, all working as additional district judges. So the purpose of my making is not that tribunal can't be there, but the same, in fact, under the election commission, if election petition is to be filed, a High Court judge becomes the tribunal to decide that issue. If you take that Unlawful Activities Act, where you have to ban this SIMI or all these organizations, a High Court judge becomes the tribunal. So why could the existing system not be adopted? You would have saved on infrastructure, you would have saved on everything, and probably done a better job, to my mind. I only want to share with you a Law Commission's report before I end. This is the first Law Commission report of 1958. And it says, on the creation of tribunals, it would be derogatory to the citizens' right to establish a system of administrative courts, which would take the place of ordinary courts of law for examining the validity of administrative action. It may be that in view of the inherent advantages of like speed, cheapness, and procedural simplicity and availability of special knowledge in extrajudicial tribunals, these may be useful as a supplementary system. But it will not be right to conceive them as a device to supplant ordinary courts of law. It would be unthinkable to allow judicial justice administered by court of law to be superseded by executive justice administered by administrative tribunals. It would be a step forward to erect the place of deliberate judicial tribunals restrained by formal procedure and deciding according to the notions for the time being administrative officers, unfettered by their rules, so that what general interest or good conscience demands, so conceived, the administrative court might well be regarded as a court of politicians, mark these words, as a court of politicians enforcing a policy, but not a court enforcing law. A description which Maitland gave in this court on Star Chambers. The very same Law Commission, however, unfortunately, subsequently changes its view and brings to this. We all hold judiciary in great esteem. I only pray and wish you all good luck, and again request you that you need to look at something that we must be able to assist our tribunal in a better form. To me, the act which is before coming into force or just come into force has already got 39 circulars coming through, and people are pointing out their deficiencies. You will have to assist your tribunals wherever they are to see what can be done best about it. Keep your flag high, because with you rests how this act is going to function. The topic that you have chosen, I was wondering, changing the contours of the corporate litigation, I don't know, it will change for good or bad. All that rests on you, not on anybody else. So please take up this challenge and do your best. Thank you so much for this opportunity.
Thank you, Chandiok sir, for delivering keynote. I believe member must have motivated from this keynote. I recognize the presence of Central Council member CS Satwinder Singh, CS Ranjit Pandey, and CS Vinit Chaudhary. And members, we will take 10 minutes break, and after that we will start with first technical session. And I invite Chairman NIRC CS Manish Gupta, please come and present a memento to Chandiok sir, please. NPS, you please join also. NPS. Central Council member, please join. Vinit sir, Satwinder sir, please. Ranjit sir, please join, please. Vinit sir, please. Saurabh, please. Thank you. Thank you, sir. Wonderful. Yeah, thank you.
Mr. Tikku is already here, so we would request for a very short break. Please come back as soon as possible.